So far as timing is concerned, I was due to finish at 2:30.
This is true.
I started 4 minutes late.
It was all of 4, was it?
And Mr. Randall has agreed, subject to the court, to give me 6 of his minutes. So I will then finish at 2:40.
2:40, right.
And Mr. Randall...
And Mr. Chamberlain, having taken up slightly more. Mind you, we're a bit late coming into court, so let's hope it all sorts itself out.
Oh.
Yes.
Yes, indeed. Romer, then, bundle to tab 12. As we say, as you would have seen in our printed case, it's paragraph 57, MS 3029, we say that the facts of Romer are even further removed from those of the present case, and that it is of no help at all in deciding whether a provision such as paragraph 18 is compatible with the directive. Now, Mr. Romer, as we see, and I think you have already seen, paragraph 22 of the court's judgment, page 413, Mr. Romer claimed his pension in 1990. His pension took into account all of his service from 1950 up until 1990, but it was calculated in a discriminatory way. As we've seen, there was a special tax break for married persons, which didn't apply to people in registered life partnerships. Mr. Kavanagh explained to you yesterday that the mechanism of taking off the tax before the pension was paid was in effect a convenient shortcut, because the same authority was also responsible for levying the tax. So instead of paying the gross pension and collecting the tax afterwards, it took the tax off first. That convenient shortcut had the effect, however, as a matter of law, that this case was all about pay, because the tax taken off all went to determine how much pay Mr. Romer would receive in his pension pay packet each month. So that's why we're in the scope of this directive at all. And we say that this issue about deduction of tax isn't an issue regarding access to a pension benefit. Just thinking of the wording of paragraph 18. It's not about whether past service should be taken into account in calculating a pension benefit. There's no question of contravening the principle of making unlawful what was lawful at the time that it was done. This is all about how the tax is deducted month by month from November 2001 when Mr. Romer first asks that this should be done. And in paragraph 64 of the judgment of the court, and you have seen this, it's at page 419, this is the answer to the part of question 5, to the effect that between November 2001 and December 2003, the directive didn't apply to regulate the amount of tax which should be deducted from Mr. Romer's pension. It only came into force in December 2003, and that is, we say, an endorsement of the principle that I've been repeating over and over again, because the directive would not make unlawful what was done in that period between 2001 and 2003 perfectly lawfully at the time. Paragraph 66, then, which I know you've also seen, is the ruling on Barber, and the question asked is very similar to that in the Maruco case, and we can engage in similar speculation as to why it was asked, and again the explanation seems to be that the referring court thought this looked a little bit like Barber. It's pension falls within Article 141, there's contributions somewhere in the picture, maybe it's Barber. But just as in Maruco, that was, as it happens, a thoroughly bad question to which the right answer was given by the court. Now, Lord Reid was asking, what does paragraph 66 mean? And the fact that there are a number of difficulties with paragraph 66. In the second line, the court says that the dispute in the main proceedings relates to entitlement to a supplementary retirement pension. Well, that's wrong. It didn't relate to entitlement to a supplementary retirement pension. There was no question that Mr. Rowan was entitled to his pension. The question was how much tax should be deducted from it. Paid from 1st of November 2001. Well, of course, the pension had been paid since 1990. Not since November 2001. It was only from November 2001 that Mr. Romer became eligible, he argued, for the more favourable tax treatment. Then the court goes on to say, well, the nature of this dispute is not such that it falls within Barber, and there are a number of reasons why that is an entirely correct finding. It's not a sex discrimination case at all. The criteria which were laid down in Barber weren't satisfied in this case. Just because the court says this is about a pension which was based on contributions doesn't mean that Barber applies. Well, of course, that's absolutely right, and nobody says that the court gave the wrong answer. And we say that there is similarly no doubt that this answer in paragraph 66 is of no assistance to the issues which arise in our case. We say that the point at issue in our case, which is whether the directive requires equalisation of pension rights which were accrued before it came into force, simply didn't arise under the domestic provisions and the facts of the case in Romer. It wasn't a question that was referred by the German court. It wasn't argued before the Court of Justice. It wasn't decided by the Court of Justice. And the Court of Justice makes no reference to the future effects of pensions case law, which as we know, it's the future effects principle, which is the governing principle about the effect of new legislation when it comes into force. No reference to that at all, and simply no question of treating as unlawful conduct which was lawful at the time. Indeed, to the contrary, there's the explicit finding in paragraph 64 that that should not be done. So Mr. Chamberlain says again what he said in relation to Maruco. Well, if the Secretary of State was right, then Mr. Romer should have got nothing. But again, that is because Mr. Chamberlain says there's a much more serious restriction on pension entitlements which is lurking in the background, that it's bizarre that the court didn't realise that. But of course, that's not what we're saying at all. We're not saying the directive imposes a restriction upon the recovery of pension. What we say is it permits member states in relevant circumstances to limit retrospective effect. So no help, we say.
You're taking really the line of Lord Justice Lewison that this was an unnecessary wrong answer to the wrong question, as it were, or unnecessary answer to the wrong question. Is that right?
Well, Lord, whether it was unnecessary.
My difficulty is if one looks at the Attorney General's discussion of this, there's no suggestion. This is at page 405 to 6. There's no suggestion there that it was an irrelevant question which shouldn't have been asked. It's dealt with, but they say, well, we haven't got any evidence of financial problems, so we can't really take it further. But it's certainly regarded as a relevant question.
Yes. Well, Lord, absolutely. I think the question is relevant if it is interpreted as a question to the court, should you limit the temporal effects of this judgment in Romer? Not is this judgment subject to the temporal limitation which you already imposed in Barber? Plainly not. But should the temporal effect of this judgment be limited? That's an
abstract question. It'd be nice to know the answer to, but it's got nothing to do with the case.
Well, no, but if the circumstances of genuine legal uncertainty plus catastrophic effect on pension schemes were made out, then it could be relevant. This could be a case for a Barber limitation, but those weren't made out, and of course the court had already said in Maruco, which was decided around about the time Romer was referred, the court had already said no Barber limitation in that case, so there wasn't going to be one here either. But Well, Lord, again, one can speculate, why was this asked? How did the court view it? If you start from the point, is it of assistance to us in our case to answer the issues that we have to answer, we submit plainly not.
Well, what he's saying is that if you're right, and the correct way of viewing these various claims is that they are claims to something which was earned by reference to service before the change of law, and that is prevented, it would equally have prevented these claims. That, I think, is what he's saying.
Yes.
And is he right about that?
No, my Lord, he's not. Because what, in Morocco, the pension which was being claimed simply was not based on past service. There was no question of having to pay pension in respect of.
Well, it wasn't based on years of service. It was based on contributions, by the look of it.
Yes, it was a defined contribution scheme. The pot builds up, and then the pot gets paid out whatever it happens to be. Wow. Barber doesn't apply to defined contribution schemes. Wouldn't apply in this country. Wouldn't apply in Germany. Barber is about defined benefit schemes where people build up pensionable service, including at a time when the law was thought to be something other than what it was. And when one gets to Roma, well, yes, it is a pension that's based on contributions, but the contributions have nothing at all to do with the case. The years of service have nothing at all to do with the case. The question is how much tax should be taken off the pension before it's paid. Again, if that were to happen in this country, paragraph 18 would simply not apply. There'd be have no relevance to the case at all.
Yeah.
That's it. But on any view, there is no reference to the future effects principle. There is no reference to the issue, which is common ground across the two cases, must be the issue when one is looking at coming into force of new legislation, effect on previous rights. Now, the Paris case, then, you go back to volume 1. The Court of Justice judgment at MS 301, that's in tab 8, volume 1, MS 301. It's paragraph 55 to 61. Mr. Chamberlain cantered through it earlier on. 55 on 301 sets out the complaint of indirect discrimination because homosexual workers born before 1951 simply couldn't marry or enter into a civil partnership before their 60th birthday. And the court goes on, as you have seen, to hold that it's not indirect discrimination because of the reasons provided in 57, 58, 59 and 60. And in particular, 59, member states are free to lay down the date from which an alternative civil status is to have effect. And 60, EU law did not require Ireland to provide before 1st of Jan 2011 for marriage or civil partnership, nor to give retrospective effect to the Civil Partnerships Act and the provisions adopted pursuant to that Act, nor, as regards survivors' benefit, to lay down transitional measures for same-sex couples who had already reached the age of 60. Now, the short point, and the point that's addressed by the court here, is that Dr. Paris's complaint sought precisely to give retrospective effect to the introduction of civil partnerships in Ireland. He had passed the age of 60 in 2006 without getting married or entering into a civil partnership, hadn't been introduced by then, and so he did not and could not satisfy the condition for survivor's benefit. That was a lawful state of affairs in 2006 when it happened. Didn't constitute sexual orientation discrimination at that time. And what the court is deciding, we say in 57 to to 60 is that it is not open to Dr. Paris to come along later after the status of civil partnership has been introduced and to ask the pension scheme to undertake to pay a survivor's pension, and when they refuse, to say it's discrimination contrary to the directive which has since come into force, or it will be discrimination in the future when I die. You can't come along later in those circumstances. Now, if you understand Dr. Paris's claim in that way, it is very similar to what Mr. Walker is seeking to do in this case. What happened to him was perfectly lawful at the time that it happened, but he comes along later, after the introduction of civil partnerships, and says, well, I wasn't able to fulfil the conditions at that time. Now I can. Now I need a commitment that the survivor's pension will be paid. Very similar. And that is why
Mr. Paris had, as it were, missed the boat. You know, his 60th birthday had come and gone. He'd failed to meet the condition in order to qualify for the benefit. End of story. That door had closed.
Yes.
And he couldn't reopen it
Yes.
subsequently because of a change in the law.
Absolutely.
Whereas, I mean, it would be said against you, but in the Walker case, the possibility of his marrying following his retirement was always a possibility, and the only problem was that under the old rules, marrying a same-sex partner wouldn't qualify him for a pension, whereas as a result of a change of the law, that future possibility could have a different legal consequence.
Yes. Well, it was always open to Dr. Paris to marry a woman before the age of 60, but he didn't. Mr. Walker has missed the same boat that Dr. Paris missed because during the time of his service, the law did not prohibit discrimination on grounds of sexual orientation.
But no, surely there's a distinct difference between the two. As my Lord points out, Mr. Paris missed the boat because he didn't get married until he was 63. And the domestic law said that you couldn't take advantage of survivor's pension if you married after 60.
Yes.
By contrast, there is no such restriction applicable to Mr. Walker.
My Lord is absolutely right. But what is happening in both cases is that the claimant is coming along and complaining in substance about something which was perfectly lawful at the time that it happened. In Dr. Paris's case, what was perfectly lawful was that he was able to pass the age of 60 without being able to marry, and so not qualify for the survivor's pension. That wasn't discrimination on grounds of sexual orientation. In Mr. Walker's case, what wasn't unlawful equally was for him to accrue a survivor's pension that was only payable to a spouse. But what it's that similarity which caused the UK government to intervene in the Paris case and to argue against the retrospective effect of the introduction of civil partnerships to protect paragraph 18 as it happens, and we were successful in that. The judgment of the Court of Justice is based on exactly the same principle of legal certainty and protection of legitimate expectations that I've been repeating over and over again. The introduction of the new civil partnerships legislation in Ireland should not be regarded as rendering unlawful getting to 60 without being able to marry, which was perfectly lawful at the time that this occurred. Now, going back to the Advocate General, if you are with me on the Maruco and Romer cases, then you must also agree in my submission with what Mr. Kavanagh said to you yesterday about the problems with her analysis in paragraphs 37 to 43. But in my submission, it's even more important to look at paragraphs 99 to 108 of the Advocate General's opinion, which is where she dealt with the retroactivity point. So that's page 300 and MS 347. And in 303, and in 103, she says the interpretation of the directive which I propose here does not in any way compel the Irish state to change the marital status of an employee such as Dr. Parrish retroactively. In particular, it does not mean that Dr. Parris and his partner must be regarded as having been married on a civil partnership during periods in the past, nor does the directive oblige the national authorities to grant the persons concerned benefits that do not correspond to their marital status. And she goes on in paragraph 108. I think Mr. Kavanagh may have shown you this. The court has already given a number of rulings to the effect that when applying the provisions of the anti-discrimination directive to the present or future aspects of situations, the origins of which sometimes extended into the distant past and certainly came into being before the entry into force of those directives.
Isn't 104 what she's saying, whether it's right or wrong?
Sorry,
is a different question.
sorry, yes.
She's analysing the claim that is made in terms of present status rather than past service.
Sorry, absolutely. Sorry, it's my notes. Yes, it's 103, 104. She says precisely that they are today claiming prospectively benefits. Indeed, thank you. Thank you, my lord. Corresponding to their marital status as it stands today, not in any way claiming a basis to which their status does not entitle, and not claiming benefit retroactively, nor seeking a retroactive change. Now, my lord, this is exactly.
105 is important. I mean, she's basing herself. She's saying it's no different to Morocco.
Yes.
And you're saying the court said it was.
Yes. Well, indeed, the court disagrees with all of this, but is
that not significant?
Yes, it is. That's significant. What is even more significant, though, is 104, because this is what Mr. Chamberlain has to persuade you of.
Yeah.
He has to persuade you that he's not complaining about the past; he's complaining about the future. The Advocate General agrees with Mr. Chamberlain in paragraph 104. The court disagrees with the Advocate General and so disagrees with the argument that Mr. Chamberlain is putting forward when it comes to look at retroactivity. The court says precisely in terms this would be retroactive effect and the Irish government is not obliged to give retroactive effect.
Well, because of the 60th birthday deadline.
The difference, you see, is that the time for the fulfilment of the condition in Paris was before the change in the law, whereas the time for the fulfilment of the condition here is after.
Well, look, there certainly is that factual difference between the cases. The age of 60 being the problem in Paris, which isn't the problem here. Absolutely, but my lord, it's the same point. It's the key question in this case. Are we looking forward? Is Mr. Chamberlain's claim prospective about what will happen in the future, or is it retrospective about what will happen in the past? That's at the heart of things. That's what's being discussed in paragraph 104, and that is what the court disagreed with.
Well, you're going to take us to the point where you say the court disagreed with that.
That's what I thought I had already.
Well, forgive me, just remind me.
So that is in the previous tab.
No, not 66.
And it's 58, 59, 60.
Yeah.
And it's the no requirement to give retrospective effect to the Civil Partnership Act. The AG said this isn't retrospective effect. The court says it is retrospective effect and you're not required to do that.
Right.
So I go beyond Mr. Kavanagh, as Lord Carmouth pointed out earlier on. I go beyond Mr. Kavanagh. I say not only was the Advocate General wrong in her analysis in the earlier part of her opinion, but also that when one comes to the nub of the issue in the later part of the opinion, the issue that arises in our case, that the court made perfectly clear that she was wrong, and that it disagreed with her, and that goes for retroactivity. That also goes for her interpretation of Maruco and Romer.
I mean, this is fairly, I understood was fairly critical to your argument, that although the sort of respect which we would otherwise give to the Attorney General, Advocate General in Cocotte, is, I mean, she's nodded here and she's probably nodded somewhere else. Her whole interpretation of Maruco, you say, is falsified by the way the court deals with it.
Yes. So there are two strands to the argument. The first strand is she's simply wrong about Maruco and Romer, and that's what Mr. Kavanagh submitted to you yesterday. The second strand, which is what I'm submitting to you, it's clear that she's wrong, because when you understand what the court held. It's this passage 57 to 62 of the court's judgment, which is critical. So, regarding the ECHR, then, part 4 of my submissions, when the court asked Mr. Chamberlain about his stance on a reference to Luxembourg yesterday, I thought what he was going to say, and perhaps what he should have said, is that he doesn't need a reference because he's going to win on the ECHR in any event. Now, that wasn't his answer. And the truth is that nobody has ever thought that Mr. Walker could win on the ECHR if he fails on EU law.
But the ECHR is in any event not a lot of use to him, because the most he can get out of it is a declaration of incompatibility. So of course he's going to go for EU law first.
This is true. But Milady, if he cannot succeed, if he does not succeed, and this is if we get to this stage of the argument, he does not succeed on the EU law principles, which don't incorporate any test of objective justification, if he can't succeed on those principles, then we say he cannot succeed on the ECHR principles, which include centrally a generous test of objective justification in this sphere. Now, just some short points on the ECHR with reference to our written case, first of all, at paragraph 72. First point, the position, the reference to that is MS 3035. The position of the UK vis-à-vis the introduction of civil partnerships can be no worse under the ECHR than it is under EU law. Under EU law, it's a matter for member state discretion whether to introduce the equivalent civil status, see Romer and Maruco. Under the ECHR, even by 2010, in the Schalk case, Bundle 4, Tab 50, MS 1192, the Strasbourg court was saying that Austria was not too late in introducing civil partnerships in 2010. And it wasn't until Oliari in Italy, 2015, that the Strasbourg court held that a state was obliged to introduce some form of equivalent civil status. And certainly, the Strasbourg court has never held that, as and when it does choose to introduce that equivalent civil status, that all aspects of the status must be equal to marriage. And we've cited various authorities where that wasn't the case. The second point then, paragraph 73 of our case, there is no support whatsoever in the Strasbourg case law for the proposition that once a new civil status is introduced, that it would be discriminatory not to equalise pension benefits retrospectively. And it's a common complaint, survivors' benefits for same-sex spouses, as you've seen. There's no support at all in the Strasbourg case law. The claim would fail in Strasbourg because the applicant was not in a comparable position to a married person throughout the period over which the survivor's pension would allegedly have accrued. And you have the Thomas and Spain case that we have cited, where the Strasbourg court rejected a more refined argument than the one I've just suggested. The applicant said that Spain should have allowed for retrospective effect of a survivor's pension for civil partners because heterosexuals who had equally been in the position that they couldn't marry because they couldn't divorce, heterosexuals had been allowed retrospective effect when the law changed and they were allowed to divorce. Now, it would be entirely contrary to Thomas, very surprising indeed, if there existed a more fundamental claim whereby Spain should have equalised Mr. Thomas's rights regardless of how it had treated heterosexuals in the past, because you simply had to introduce everything with retrospective effect. That simply doesn't stand with the Thomas case. Third point then is justification. A difference in treatment in the field of pension benefits will be lawful unless the justification advanced for it is manifestly without reasonable foundation. We referred to the Brewster case in our printed case. That in that case, the justification test was applied a little more stringently, where there was no, according to the court, there was no genuine economic or social policy lying behind the policy choice to require a nomination form, and indeed no consideration of the policy choice at the time that it was made. Now, our case is very different, we say. There is a genuine policy choice at the heart of our case and our justification. It is a choice based on the protection of legal certainty and legitimate expectations. It is a choice not to make unlawful conduct which was lawful at the time. It is a choice to change pensions law in this respect in the way that pensions law is usually changed prospectively for future service and not for the past. Now, it happens to be a policy choice based on fairness, legal certainty and so forth, which would have a real practical impact if this court were somehow to reverse it. And we've given you the figures, £100 million, £20 million, and I perfectly accept in the grand scheme of assets of pension funds, those aren't large figures, but they may be significant figures for some pension funds, for how it affects some pension funds. And I don't have to show in my submission that there would somehow be a catastrophic impact on pension funds if the policy choice were reversed. As Lord Justice Underhill said, we said perfectly fairly, this isn't about whether the balance of schemes would be seriously unsettled. This is about legal certainty, legitimate expectations, not making unlawful what was lawful at the time. Finally, I think it was said by Mr. Chamberlain in argument that there was no evidence to suggest that these policy considerations, and that they're set out in the appendix to our case, as you've seen, that these policy considerations were actually thought about at the time that paragraph 18 was introduced. Now, our position is that these basic principles were very much in the mind of the decision maker, which was Parliament, when enacting paragraph 18. Why else would paragraph 18 be there? But neither Mr. Chamberlain or his predecessor, Miss Lester, at the EAT level, have ever said until today that we need a witness statement to prove exactly what was thought about by the minister who proposed the bill, or who thought about the bill before it was put before Parliament, or anything like that. It's been accepted, and certainly no challenge has been made on that basis, that these are the policy considerations which underlie paragraph 18. Now, if I need a witness statement, I'll get one. But because it wasn't said until today, I don't have one. Finally, so far as a reference is concerned, my submissions are the same as Mr. Kavanagh. We say that the EU law point is clear in our favour for the reasons that the Court of Appeal gave. And if it wasn't clear then it is clear now following Paris. There is, we say plainly, no requirement of EU law to make unlawful what was lawful at the time that it occurred. And those are my submissions, unless I can assist further.
Thank you very much indeed, Mr. Coppell.
Oh, I'm sorry, I can assist further. Lord Hughes...
Well, we'll be the judge of that.
Well, yes, in fact, you may not think this is of any help whatsoever, but Lord Hughes asked for the definition of accrued.
Just tell me where it is, Mr. Coppell.
Well, it's Pensions Act 1995, section 124, subsection 2, and you will be enlightened to find out that the accrued rights of a member of an occupational pension scheme at any time are the rights which have accrued to or in respect of him at that time to future benefits under the scheme.
Well, that's a definition of accrued rights.
Okay.
It's not a definition of accrued.
Well, there is references to accrued pension or accrued benefits are to be interpreted accordingly.
All right. Thank you very much.
That's it.
Thank you. Thank you very much.
My lady, my lords, not for the first time in this case I appear as tail end Charlie, representing obviously the respondents below, which is Innospec, who are the employer, and the 7 individual trustees. You'll no doubt be grateful to know that I don't propose to address you on Maruco or Roma, because the submissions I make are based on the position being that the court is with Mr. Chamberlain on all of those relevant issues that have been argued. But our position on the remainder can be summarised shortly. And we say that the appeal against us must fail in any event. And we say that by using 3 building blocks. The first is that what's unusual about this hearing compared with the hearings below is that there is an admission at this stage that paragraph 18.1 of Schedule 9 to the Equality Act cannot be construed in a manner consistent with the way in which Mr. Chamberlain says the directive requires. And we say that that admission is striking because his case is now effectively Hamlet without the prince insofar as it applies to us. And that is for 2 reasons. The first is that that concession now means he is forced in the Cuca de Verci area, where we say Paris, on that point, regardless of what anybody else says about any of the cases of the Court of Justice here, is quite clearly against him on that particular point. And he must lose, we say, on the Cuca de Verci test. And secondly, even if we're wrong about that, he has argued himself out of a remedy against my clients. And the reason he has done that is because his case is based on pure hypotheticals. He says, my right has not even accrued yet, or quite how the court can give a declaration in relation to a right that has not yet accrued, we do not know. And secondly, it is based upon a jurisprudence which we say, on the basis of what may well happen in relation to Brexit, may well not exist at the time at which he claims the right will finally accrue. And we say his cause of action, as is often the case, can be actually analysed as failing when you actually look at the remedy that he seeks. Before we come on to those points, I wonder if I can say a few points about context and the individual circumstances of the scheme in this case. First of all, the anti-discrimination provisions in relation to pension schemes operate through Section 61 of the Equalities Act, and that imposes a non-discrimination rule within the scheme. And the persons held responsible for that are the employer and the trustees. But that is not clearly the limit of the legal obligations that apply to employers and trustees in relation to pension schemes. And we say the context is highly relevant here and puts into context the way in which my learned friend Mr. Chamberlain opened his case. The sorts of obligations that also apply relate to the legislative framework post-Maxwell. Post-Maxwell,
Okay.
my lord. In particular, they apply to funding. So there are now minimum funding requirements, which of course have met criticism because the argument is the funding is never enough. And as a result of the minimum funding requirement, everybody now funds to a minimum rather than what should be required. Secondly, they are controlled in relation to investment. So if you are in deficit, you cannot embark on an ambitious investment plan in risky investments to make up the gap. Thirdly, you cannot, in a final salary scheme, rob Peter to pay Paul because of Section 67 of the Pensions Act, which I know Mr. Coppell handed up to you earlier today. And Section 67 is interesting because it provides protection for accrued rights. And one of the points that I would suggest that should be on the court's mind when considering Mr. Chamberlain's arguments about accrual is that he should be careful for what he wishes for. Because the normal position of the member of the scheme is to say, please say my right has accrued. The reason they say, please say my right has accrued is because all the pension protections legislation is based on accrued rights. And if he says it's not accrued, potentially it's in the scope of amendment without the protection of an actuary saying that this particular provision doesn't undermine or harm member. Furthermore, schemes face, as we all know, a funding crisis of this nature. And the funding crisis arises because of longevity, coupled with lower investment returns. And as has been noted by the court, the reality is that final salary pension schemes are closing, or they're being closed to new members, or there is stress on the funding resulting in lowering of future benefits. So in addition to those statutory requirements, the trustees are obviously subject to the normal rules of trust law. And secondly, the employer is subject to further controls under the implied term of trust and confidence arising from the seminal case Imperial Group Pension Scheme. So we are in a position in which the trustees and the employer have their hands tied to a very large extent. And when one looks at the facts of the particular case here, you can see that. So if we look at the Employment Tribunal decision, which is in the core volume, page 3109, looking at the evidence that was before the tribunal, the court will see at paragraph 3 that it was a very genteel hearing when it came to the evidence. 3 witnesses were called, none of them were cross-examined. And the key evidence, I think, is at page 3110. You'll see at paragraph 5.9, the evidence given as to the funding deficit in the scheme. So it's 1.5 that it required funding deficit to be addressed, 1.5 million 5.8, 6.9. So the scheme is in deficit. And to assist the court at 3114, the rather long paragraph 16 in the tribunal's decision, there are two particular points which I think help to show the context here. The first appears about just over halfway down, where you'll see Mr. Yondel's evidence was accepted that the cost of providing would be at least £400,000. And then towards the bottom of the page, there's the further evidence that it's one of those ironies that a piece of evidence that is very harmful to you in a discrimination case but would assist in relation to trustees' duties is the fact that the scheme couldn't really come up with any cogent evidence as to what the relevant numbers would be in the future, because they simply didn't know how many members of the scheme are gay or lesbian, or how many have entered into civil partnerships, and as to when they joined the scheme. So that's the dilemma we say that the trustees face in a case of this nature. And when one looks at paragraph 18.1 to Schedule 9, which is in the Authorities Volume 2, tab 21, page 581, you will see why, for trustees and the employer in the position of this employer and trustees, came to the decision which they did. So it's page 583, I apologise. And it's because the advice that is given to trustees in that position is invariably, if you have a deficit in the scheme, you must address that before you take on additional liabilities that you are not legally liable to take on. And the concession in this case that this provision cannot be construed in a manner consistent with the way in which Mr. Walker says that the directive requires, we say is significant, because at the time at which this decision was made, the trustees and the employer, we say, had no practical choice. And that's different to saying the scheme is at risk of financial catastrophe. That's not the test. It's the test of prudence, financial prudence for a trustee. So the court should be in no doubt that there will be hundreds of pension schemes up and down the country that have done exactly what this trustee, these trustees and this employer has done. Whilst we're on paragraph 18, I think it's worth looking at it and seeing why it blocks the claim. It is a transitional provision. There can be no doubt about that. And what it does is it limits retrospectivity. And we say this is crucial because this is precisely the provision that arose in Paris. And that is why my learned friend cannot succeed with paragraph 18, because it limits retrospectivity. Nothing else, there's no other reason. That's the reason why. And as the court will appreciate, it is specific, and as accepted now, it is directed precisely at this type of case. And now we have the admission that paragraph 18 cannot be construed to save Mr. Walker's case.
Why does it have both A and B
Or
if the respondent's case is correct? If Mr. Kavanagh is correct, the rights accrue from week to week with each week of service, in which case you wouldn't need B at all.
Well, Madam, that's an issue for Mr Kavanagh's case, not an issue for my case.
It's only just occurred to me.
I confess I had wondered when the point was going to be made. That, it's arguable.
Oh, I'm so relieved we've got that.
No, I don't mean
5
it
to
that
3.
way. What I meant is, this is obviously the first time we've looked properly at it, but I did wonder when the point was going to be made, why is this necessary? But I think we would say it's necessary for the purposes of clarification, and indeed, as it's a temporal provision, it is different to the standard rule. But we say that then forces him into Cucca-Diverci territory, as he accepts. And we say Paris determines that question against him conclusively. And we rely upon it in a different way to the way in which my learned friend Mr Coppell relies upon it, because we're obviously dealing with the nuclear option of saying you just ignore what the legislation says. It's in the Authorities Volume 1, Divider 8, at page 302. And we say the relevant paragraphs are at 57 through to 62. No doubt the court's already seen these, and I've been referred to on several occasions. But we say there is simply no escape for Mr Chamberlain in relation to these paragraphs. It cannot be said that these words of principle are solely based on the fact that, in this case, Mr Paris missed the boat earlier than the boat that Mr Walker hopes to catch. That isn't what this case is about. This case is a pure case of principle about the scope of the directive. And paragraph 60, we say, could not be clearer. You are not required to have retrospectivity. And we say that point is clear. And of course, what is relevant in relation to this particular argument is that the way in which the Advocate General put the case was to run the Cucca-Diverci argument. It was the final port of call. And if we look at the Advocate General's opinion, which is behind Divider 9 at page 347 in the same bundle. Taking it down from C, you see the autonomy of member states to regulate marital status, which is the key issue under question 1. And paragraph 107 is where you see the key passage in relation to Cucca-Diverci, which my learned friend Mr Chamberlain relies upon. And at 108, the Advocate General says, that is precisely the case here. So she was saying, Cucca-Diverci wins the day if I'm wrong about what's gone before. And you can see her intermediate conclusion at paragraph 110. Where she says the answer to the first question that must be in the affirmative. And we know that the court rejected that emphatically in its actual decision at paragraph 77. If my learned friend is correct about Cucca-Diverci, Mr Paris had to win. Because he says, it doesn't matter, provided at the time that the case is brought, it's a general principle of European law, that's enough, and it sweeps all before it. So So he has to explain to you why Mr. Paris loses, notwithstanding that argument, and we say he cannot.
I'm not sure I'm following. Mr. Paris lost because he couldn't meet a discriminatory requirement which existed and he had to fulfill before the anti-discrimination law came into force.
Yes, but as I understand it, the argument that is brought, what is said is that it doesn't matter that the time for transposing the directive has passed. So his argument must still be, as the Advocate General puts, this is the complete answer.
The Advocate General had held that the age requirement was discriminatory. She reaches that conclusion in paragraph 99. So she's knocked that out, whereas the court obviously thought that it wasn't objectionable under EU law.
Well, certainly, but the key issue is still the argument. We say that if the Advocate General is correct, then the court could not come up with paragraphs 57 to 62, we say. So we say that they must lose under Cuca de Virtue because of Paris. We then get to the final point, which deals with remedy. And the way the case is now put against us is on the basis of Cuca de Virtue, which says, in essence, you can disapply a provision of national law. We say that falls precisely within the ambit of what is likely to be a controversial area, if I can put it as low as that, in relation to the Great Repeal Bill. Because it involves the supremacy of European law and principles over Parliament. We don't say it's definitely going to happen, but it must be a likely or possible outcome. Against that background, and in circumstances in which my learned friend says his right does not accrue until Mr. Walker dies, it is difficult to see how the court can possibly grant any declaration as to rights at this stage. Because you would simply also clearly have to be saying there's liberty to apply if something happens between now and Mr. Walker dying. So we say that the consequence of surrendering on paragraph 18 is that there's no provision on which the claim against us can now bite in terms of remedy.
Is it really a matter of simply being careful as to how one frames the declaration?
Sorry, my Lord.
I'm wondering if there's more to it than simply being careful as to how one frames the declaration. I mean, for example, if you said under the law currently in force, Mr. Walker's partner will be entitled to a survivor's pension in the event that he survives Mr. Walker's decease and is married to him at that time.
But what we would say is, well, what is the point of a declaration of that nature?
Yes, it settles the law for the future.
Well, it doesn't settle the law for the future. It settles the law for 24 months, perhaps. But it doesn't settle the law for the future. And also, it doesn't give any...
Sorry, just let me understand that argument. You're saying that we should be deflected from making a declaration because within 24 months or whatever time is required, this will not be a remedy available to Mr. Walker. Is that what you're saying?
Well, no, what we say is that there are too many hypotheticals here, because the right has not yet, on his case, the right has not yet accrued.
It could accrue at any moment.
It could accrue at any moment.
Well, let's avoid the very difficult word accrual, because I'm not sure everybody's using it in the same sense. The right has not fallen into payment.
We say it is by definition hypothetical. And there's the obvious point that we would also make is that by doing that you do not deny Mr. Walker his other potential remedies. They're just not against my clients. And indeed that would be the far more efficient way of making those relevant declarations as to the law, rather than as against my clients.
So supposing this is a very big if, that we are so far with Mr. Chamberlain on his EU law points, and therefore consider that the survivor's pension should be payable, and then, which I hope he doesn't, Mr. Walker dies tomorrow, who would pay the pension?
Well, there would potentially be a Frankovich claim against the state.
Against the government. Well, that's interesting.
But the mere fact that the debate goes on, we say, is a good indicator that you shouldn't be making the declaration. My Lady, my Lords, I've had a note from Mr. Kavanagh, who asks if I can respond to the question from the court, if I can read out what he says, if that's permissible.
Why not?
The issue
Happens all the time. Well, not from Mr. Kavanagh. Leading counsel on their feet, read out notes from those behind them all the time.
It starts Nick, John here. But I think I'll get to the key bits if I can. One, the issue before this court is that EU law... He's not even a doctor. The issue before this court is what EU law says about when pension rights accrue. That can't be affected one way or another by a provision of domestic legislation. 2, paragraph 18 is not just about pensions. Paragraph 18.2 may be understood as belt and braces. It is not unusual for two domestic provisions to overlap in order to provide certainty.
That's his answer to my question, yes.
That's his answer.
Well, the first one, I think, is his answer to some other question.
I'm grateful. Unless there's anything else on which I can assist the court, those are my submissions.
Thank you very much indeed, Mr. Ryan. Mr. Darwin?
Fascinating day.
Lady, sorry, can I just jump up? I think as paragraph 18 applies in my case, and also Mr. Kavanagh's, I should also try to answer your question, and it is the belt and braces point that he makes. In the case of a pension scheme like the Innospec scheme, both belt and braces apply, but there will be some types of employment benefits, some types of benefits under pension schemes, which don't fall within both and only fall within one or the other, and there are so many different ways in which rights may arise that that's why it's there.
Thank you.
I hope I wasn't distracting the court or Mr. Coppell by moving forward as he was speaking then. I didn't mean to be rude, so apologies if it appeared so. My Lady, the running order for reply is me before Mr. Chamberlain, and I have drafted a note of what the reply will be, which if I can just hand up, hope it will deal with all the points that I have to address Mr. Kavanagh, although there may be some points that I want to just add shortly to from Mr. Coppell. Can you pass those along? Thank you. I don't propose to read all of this. Some of it is quotations from the cases which are more conveniently put in documentary form so that they're there and available for you. My lady and my lords, we submit that when you come to look at this case, you really have to take as a starting point the fact that there's a paradox at the heart of the MOJ's case about the future effects principle as it applies to Mr. O'Brien and Mr. Miller's case. Mr. Kavanagh, acknowledges that the FEP is a rule of European law, but there's a strange submission as to how it applies. He's repeatedly stated that the MOJ accepts that the future effects principle applies to ensure that Mr. O'Brien is enabled to rely on his period of office prior to the transposition date for the Part-Time Workers Directive, whilst also asserting that it does not allow him to rely on the future effects of his actual service. And our submission and reply in summary is that this is plainly contrary to the conditionality of the JPRA, and there's nothing in the case law to maintain such a distinction. Indeed, we submit the contrary is the position. The Court of Justice has refused to accept a submission that the Part-Time Workers Directive does not apply to facts that took place before the transposition date. And that's why we respectfully submit that the Court can be completely confident about the starting point of its consideration if it starts with the precise text of the judgment of the Court of Justice in the case in O'Brien. And I want to just open that for you. It's in Bundle 6, and if you'll go straight to 2951, you can see then moving forwards to, I've got 2055, I wonder if I've made an error of the, I think it's 2055 is correct. Yes, 2055 is correct. I think that the reference 2951 should be 2051, but 2055. This is the passage that in which, first of all, Advocate General Kokot dealt with the Latvian government's submission. And you'll see, the submission was that the Latvian government has doubts as to the admissibility of the reference. And then in paragraph 15, this is the really important bit for you, the Latvian government considers that the directive can be applied only to events occurring after the expiry of the transposition period, or at least since its entry into force. That was the precise submission that Advocate General Kokot was dealing with, only to events occurring after the expiry of the transposition period. And it was in that context that the FEP was set out in paragraph 16 and the submission was rejected. You can see, therefore, events before the transposition date were in scope for the Part-Time Workers Directive for the Advocate General. It's put slightly differently in the judgment. The judgment has it at paragraph 24, and the court deals with a submission from Latvia as concerning not just events but facts. I put it in the box. The submission is that to hold it would be wrong and contrary to the principle of legal certainty to hold that the directive may apply to facts which took place before the entry into force of the directive. And that submission too was rejected. I've simply put paragraph 24 where the court repeats the submission from Latvia. If you go to paragraph 25, you can see that the court repeats the FEP. It's page 2057 in the bundle and rejects the submission. So we, on this side, start from this point that there is an authority in our favour, more precisely one which concerned Mr. O'Brien himself, that the Part-Time Workers Directive applies to the future effects of facts or events in Mr. O'Brien's service as a recorder that antedated the transposition date.
So 2057 is the Advocate General's opinion.
My lord, I'm sorry, I didn't catch what you said.
2057 is the Advocate General's opinion.
Yeah, that's right.
Sorry, I thought you were referring us to
The
judgment of the court.
Paragraph 24 is in the CJEU's
judgment.
But am I right, Mr. Allen? The Latvian submission which was being rejected was the directive is simply irrelevant because most of its service predated it, even though some of it came after.
Exactly so. That is the submission.
Yes.
And this is discussed as to exactly how far you can get out of it. But what our submission to you is, the way the Advocate General dealt with it and the way the court dealt with it, it was to summarise it as being facts or events that antedated the transposition were irrelevant to its application. And that's why we've highlighted those two precise passages which were rejected. So the admissibility decision is, of course, the key to it, because what Latvia was saying, that there is an elimine point that is being made. The reply to this, which, when this point has been made below, is to say this is simply a point about admissibility and nobody expressly referred to turnover. That is true. That is true. But equally, it is totally true that although the report for the hearing before the European Court included Latvia's submission to this effect, the UK government made no point about turnover, it made no submission about Barber, it made no submission to the court saying that this is only a case, if you like, about 4 or 5 years, somewhere between 4 and 4.5 years. Now, that's a short reply point, and really what it comes down to is saying this: you could not decide in the face of the court rejecting a submission that facts and events prior to the Part-Time Workers Directive are irrelevant. You could not make this decision against Mr. O'Brien. It would be for you to refer the matter to the European Court to say, did Homer nod at this point by not referring to Turnover or Barber or any of those issues? But to go so far as to say that it's obvious that the court had no thoughts about that and it's obvious that Turnover and Barber are against Mr. O'Brien flies in the face of the way this has been dealt with in front of the court already in Mr. O'Brien's case. Now, of course, we understand that Ms. Kavanagh seeks to answer this point by saying, in effect, that periods of service have, as a matter of law, no future effects for pensions. We understand that. We make short only reply submissions about that because, in fact, you've got the merits of our point already in what we have said, and I don't need to redevelop those. But we do say this, that there's a poverty about his response which is self-evident, because the proposition from him is contrary to reality, that there's no principled basis for denying the relevance of the FEP while conceding that the period in office is a fact that can be taken into account. And he cannot account for the failure of Advocate General Cocotte or the court to qualify its response when the admissibility question was dealt with. So we say that Mr. Kavanagh's two first founding propositions, which he claimed are uncontroversial, simply don't advance his argument or assist the court in any material way. The first, you will recall, is that all agreed that the Part-Time Workers Directive doesn't have retrospective effect. Well, of course, we agree that a part-time judge who retired prior to the date for transposition couldn't claim. Retroactive effect of that kind is not what the Part-Time Workers Directive intended, however desirable that might be. We just make a footnote, though, to remind you that since Bilker and since Preston, it's perfectly clear that in many cases part-time workers could claim indirect sex discrimination cases, not under the Part-Time Workers Directive, but under the sex discrimination legislation. Beyond that, we comment that the formulation of this first proposition begs the central question of the appeal as to what is impermissible retrospective or retroactive effect. His second proposition, that prior to the 7th of April it was not unlawful to treat part-time workers less favourably than full-time workers, is undoubtedly true, but it provides no answer to the question as to how the future effects principle applies. The whole point of the future effects principle is that new positive law changes the consequences of events that have occurred previously. That's the point of it. Mr. Kavanagh then turns to Bruno and Pettini, which you'll recall was the proposition, the case that was used as the premise for the conclusion of the Advocate General and the court in our case when it was referred. And we make some short reply submissions. I'm afraid 15A has got slightly aborted in the writing of it, so if you'd be kind enough to write a little extra there, I'd be grateful. There's no comfort for him, we say in Bruno, because the distinction he seeks to make between the differential relevance of periods of work and periods of service that occur prior to the transposition date, these are the words to add in, was not addressed by the court, except in relation to a differential approach to prorating, or prorating, I should say, and you'll see that in paragraphs 64 and 65. Secondly, the court stated in Bruno and Pettini, just as it had done in this case, the FEP in entirely general terms as applying to the Part-Time Workers Directive. And that's at MS 160 and 161. And one needs to remember that it was a fact of the Bruno and Pettini case that all or almost all of the work that was being considered for the purposes of the qualifying period had taken place before the transposition date. We've set out the passage from Bruno and Pettini in which the general statement is set out in the box. I don't read it to you. Mr. Kavanagh then next submitted that the consequence of the FEP was exorbitant in the sense that it might mean the periods of service occurred even before the relevant state was subject to European law. So what? We say there are good examples of that in the case law. There's the Land Nordrhein case. I don't have time to read it all through to you there, but we've set it out in the box. There's a further case where the exorbitant effect of the FEP rule is even greater. And it's the case of Brock, which you'll see is cited in Bruno and Pettini. It related to facts which go back to the interwar period, where the law in relation to pensions under a particular German pension scheme and European regulations were affecting the relevance of periods of service going back to 1936. I think it was, it might even be earlier. Again, all set out in the box. And the consequences we draw from that are at paragraph 27. Next, the point about being permanently fixed. In our submissions, it was key to the application of the FEP to identify when a legal situation becomes permanently fixed. And you've seen our note of A.G. Cosmos's opinion. Mr. Kavanagh made various submissions about how he thought the legal situation became permanently fixed in a range of other situations that he had thought about prior to the hearing, and he referred to the case of Venietveld, which was the personal injury case. We say that doesn't help at all. It's obvious that in a PI case, the tort or delict requires some actionable injury. Once that injury takes place, it's the equivalent of retiring. If anything, it certainly doesn't advance the case. But we do draw your attention again to A.G. Cosmos's discussion of the quite unpronounceable Finnish case of Kuisjärvi, where it was said that it's when the conditionality is complete that the FEP applies, and that we invite you to have a look again. And we refer to Lord Kerr's comment about a woman who marries a retired worker. How could her right to a survivor's pension be permanently fixed prior to the marriage at the very earliest? It must be right that she could have no rights at all during the earlier periods worked by her not yet husband. Mr. Kavanagh also referred to filing and tried to persuade you that that assisted him. We don't agree at all. Filev was the case about the, I think, Turk, it might have been Bulgarian, who was expelled from Germany and who then sought the benefit of later regulations to say that the 5 years and more that he'd been out of the country ought to be taken into account under the new regulations to permit his re-entry. And we've set out in paragraphs 34 through 35 how that is dealt with. We invite you to read it at leisure. I'm very conscious of the time that I have left. Coming back to it, whilst we quite agree with the written point made by Mr. Kavanagh just a few minutes ago that was read out to you, that the issue at the heart of this case is how European law addresses service which has a consequence in relation to pensions. We do not accept that that is the last way that you look at it. We say that what you've got to do is to look at the cause of action that the Part-Time Workers Directive creates. That, of course, is European law. And the cause of action that the Part-Time Workers Directive creates is a cause of action based on treatment. The core of it is treatment. So if you look at the Part-Time Workers Directive, in paragraph 41, in fact, actually, you have to look at the framework agreement attached to the Part-Time Workers Directive at paragraph 4.1. The obligation is that in respect of employment conditions, part-time workers shall not be treated in a less favourable manner than comparable full-time workers solely because they work part-time, unless different treatment is justified on objective grounds. So the question for any trying court is what treatment happened? And you see that again replicated in the regulations that followed. And that's why it brings us right back to the beginning of my submissions yesterday to you, that the question is, how has a comparable full-time worker been treated? Have they been treated at any point more favourably than the part-time worker? And you ask that question when retirement takes place in accordance with the JPR, RA, or the JPA. It's the treatment on which the focus is placed by the directive and the regulations. Posed in this way, the question has to be asked by the PTWR and PTWD. It focuses, as we say in 44, on the actual treatment of both the worker and the part-time worker and the full-time worker. And until the point of retirement, there is really no discernible, final, actual, less favourable treatment. What is the treatment in question in these appeals? It's the treatment on retirement. It is this point at which the FEP has to be applied, i.e. the prevailing positive law has to be applied to the existing situations at this point, whether the situation in the sense of the service or the contract started before or after the change in the law. Mr. Kavanagh's submissions in this response to this part of the case were tested by the court asking what is the position in relation to a judge who's 64 and a half. Is or her pension entitlement permanently fixed? And the answer is, of course, no, it is not. Mr. Kavanagh, though, answered shortly, yes, as a matter of law, by referring to the judgment in Collarol, but that was a diversion. Collarol is concerned in this part, in paragraph 5, by the possibility of actuarially reduced pensions. And it's true, in other circumstances, a case might arise in which a part-time worker took early retirement, pre-65. The treatment would then have to be assessed by reference to the treatment of a full-time worker who took early retirement in those circumstances. Last points, which I'm afraid are a little bit more rushed, a point about derogation. Throughout, the formulations of the FEP ask the question, or state in the formulations, that the future effects apply unless there's a derogation within the new law. Now, this is worth just shortly mentioning, in relation to the part-time workers directive, it was actually agreed when we opted out of the social charter. So there was a second directive specifically for the United Kingdom to extend its application. In the part-time workers directive itself, there was a transitional point in relation to the implementation difficulties for collective agreements, but absolutely nothing that dealt with the situation of pensions. That's Article 2.1. You've got the reference to it in paragraph 52. Reference. We only add that if the position is Act Clare in Walker, then the logic of that position must be applied with respect to Mr. O'Brien and Mr. Miller as well. We recognise that a case has been raised against us. The high point, in a sense, of its specific rejection is Advocate General Cocotte's opinion in Paris. That opinion expressly says that she does not agree with the submissions in writing from Mr. Coppell in which he says the turnover line of authority applies outside Article 119. Those submissions are in Volume 1 at tab 11, and I invite you for a moment just to have a look at those and the extent of the submissions that are made in relation to turnover. We haven't opened it in full, although it's referred to impartially in our case, but I do invite you to have a look at the depth of the submission that was made about the extension of turnover and Barber to situations outside Article 119. It's all in there.
What was the reference again? I'm sorry.
It's tab 11 in Bundle 1, commencing at page 362.
Yes.
And the temporal effect of claims of discrimination in the payment of pensions starts at 367. There are pages of it. I don't go through all of it, but it's extensive, and it essentially replicates the submissions Mr. Kavanagh had made below, and which Mr. Kavanagh and Mr. Coppell have made to you. Where does this leave us? Is this court able to mark Advocate General Cocotte's homework? I would respectfully suggest no, it is not. That is not the appropriate way to proceed unless it is confident, utterly confident, that the judgment in Paris expressly adopts Mr. Coppell's submission. And it plainly doesn't. It plainly goes off on a quite separate point about the time at which the marriage took place in Ireland. Once you accept that, as I believe you must and submit you must, you are not in a position to mark Advocate General Cocotte's homework on this. It supports our case, and it certainly means we can't lose without a reference. If you feel confident enough to find for us without a reference, we'd be delighted, but we certainly submit we can't lose without a reference. My lady, my lords, I've taken a moment over my time, but I'm most grateful to you. Is there any other question I can answer?
I think this is clear. The Miller cases, which are about time limits, stand or fall with O'Brien?
Not quite, and I've made that point in our case to my lord. There is a straightforward construction point on Regulation 8, which we've tried to set out in our case. Now, the weight of the argument inevitably has gone over Europe, but the point in relation to that is how you construe Regulation 8 and the effect on it in the context of the JPRA and the JPA. The point being very simply this.
Oh, it's set out in your case.
It's all set out in the case, but it's I can repeat it in 3 sentences, I think. But a High Court judge, moving on to being a Court of Appeal judge, is able to claim their pension, taking into account the service for all their different posts at the end of the time. The argument that's made against us is that we should have looked at the pension position as you moved from one job to another. It's set out rather more extensively in
The
the
Court of Appeal didn't deal with this.
Not in any detail at all. No, they really didn't deal with it, my lord. That's right.
They weren't asked to deal with it.
Oh, it certainly were. It's in our case to them. Yes, it was.
Right. All right, well, thank you.
Thank you.
Lady, my lords, can I start with a point that we had originally thought was common ground, but after listening to Mr. Coppell's submissions, we understand is not. And that is the question, would Mr. Walker have a good discrimination claim under the Domestic Act, the Equality Act, even if paragraph 18 were not there? Now, we say, with respect, the answer is obvious. He would. You compare two situations. One is Mr. Walker's factual situation, and the comparator is someone who is similar to Mr. Walker in every respect, save that he does not share the protected characteristic in question, namely Mr. Walker's sexual orientation. So the comparator would have the same dates and lengths of service and the same terms of service. The only difference is that the comparator would be in an opposite-sex marriage rather than a same-sex relationship. The comparator gets the pension, or rather the comparator's spouse gets the survivor's pension. Mr. Walker does not. Why not? Because of his sexual orientation. This is a straightforward, direct discrimination claim, and there is no way out of it apart from paragraph 18. And indeed, if there were a way out of it, of the kind that Mr. Coppell has suggested, paragraph 18 wouldn't be necessary. Now, this is precisely the analysis which you see in the decision of this court in Bull and Hall. Some of you, I know, will be very familiar with that decision. It's the decision about the gay couple who are denied a double room in a hotel. The facts were that the hoteliers would give a double room to a married couple. But when one drilled down into what exactly they meant by a married couple, they meant a couple in an opposite-sex marriage, a heterosexual
married couple only.
Yes. So the facts of our case are precisely analogous to Bull and Hall. You get the pension, but only if you are in a heterosexual marriage. It's direct discrimination. Now, accept, of course, that the answer wasn't clear to at least two members of the 5-justice panel in Bull and Hall, but it is now established by the majority that constitutes direct discrimination, so does this. And we say that exactly the same analysis applies in EU law. See the judgment of the ECJ in Maruco and the judgment of the ECJ, indeed the Advocate General's opinion, in Roma. You will recall that the Advocate General in Maruco thought that the situation at issue there was not direct discrimination, but only indirect. But the court put him right, and both the Advocate General and the court followed that analysis in Roma. The only question was whether domestic law treats same-sex partners and opposite-sex spouses comparably for the purpose of the benefit in issue. And the answer here is yes. As this court said in Bull and Hall, civil partners are deemed by the law to be in a comparable position to opposite-sex spouses in all respects. So this is a situation of direct discrimination. Now, on its face, the Framework Directive forbids direct and parenthetically also indirect discrimination, with effect from its transposition deadline, namely December 2003. And this means that you cannot complain about acts of discrimination that took place prior to that date. The result is there is no discrimination complaint that can be brought about a failure to pay pension on equal terms where the failure to pay, that is, the act of discrimination complained of, occurred before 2003. That is what was established in Roma. No claim, as you'll recall, for backdated pension payments, where the payments were due prior to the transposition deadline. Now, Mr. Koppel gave the example of the claimant, you recall, in Southwest Trains, Grant and Southwest Trains, which was the case where the ECJ held in 1997 or 8, I think, that sexual orientation discrimination was not, at that stage, unlawful as a matter of EU law, and nor did it constitute sex discrimination, despite the creative efforts of counsel involved. Now, Ms. Grant, Mr. Koppel said, could not complain about the failure to give her a travel concession prior to 2003, because it wasn't unlawful to discriminate against gay people prior to 2003. We agree. But as the example given by Mr. Kavanagh makes clear, she could complain about that failure from 2003 onwards, even if the rules of the scheme required that she had served for example, 5 years before being entitled to the concession. That was Mr. Kavanagh's example, if you recall. His example, I think, was the company car rather than the travel concession, but exactly the same principles apply. Now, Mr. Koppel said that the key question in this appeal is whether EU law permits member states to impose a temporal limitation of this kind. And he made on a number of occasions a distinction between permitting member states to impose that kind of limitation and requiring them to do so. Well, we say with respect that overcomplicates matters. The actual question in this case is whether claims in respect of pension referable to service before 2003 are in principle outside the temporal scope of the Framework Directive, even though that directive contains nothing equivalent to paragraph 18. Now, my Lord Reid put at one stage in argument to my friend Mr. Koppel, cannot the situation that we're dealing with really be analysed in this way? The Framework Directive requires you to treat people equally with effect from December 2003. Yes, we agree. It contains no derogation from that equivalent to paragraph 18. So the question then is whether one can find in the EU law a separate principle that claims in respect of pension referable to service before 2003 are in principle outside temporal scope. Now, because that is the question at the heart of this appeal, Mr. Koppel has to try very hard to distinguish Maruco and Roma by saying that the schemes in those cases were different schemes and the cases had elements of a contributory nature and so forth. The problem that he has in distinguishing those cases, however, is that the Court of Justice considered in terms whether the pension in those cases was referable to service. It had to consider that question because that was one of the conditions on which the pension would qualify as pay within the meaning of the Framework Directive. And the answer in Maruco's case was given at paragraph 54, see Bundle 1, Tab 7, MS 286. Now, this was part of the judgment which we skated over, and the reason I skated over it when I first opened the case is because there's no dispute in this case that the pension that we're dealing with constitutes pay within the meaning of the Framework Directive. There was a dispute in Maruco's case. That was one of the questions that was referred to the court. Does this actually constitute pay within the meaning of the Framework Directive? So if one looks at paragraph 54, one can see, actually from paragraph 46 onwards, 46 gives you the conditions under which something comes within pay. And at 46 you can see, on page 285, the court has stated that of the criteria for identifying a pension scheme which is adopted on the basis of the situations brought before it, the one criterion which may prove decisive is whether the retirement pension is paid to the worker by reason of the employment relationship between him and his former employer. That is to say, the criterion of employment based on the wording of that article, that being Article 141. And one goes on, one can go on, read on to see how that was applied. But if you then go forward to paragraph 54, you can see, as regards the criterion that the pension must be directly related to the period of service completed, it must be observed that under the relevant German regulations, the amount of the retirement pension by reference to which the survivor's benefits are calculated is determined by reference to the period of the worker's membership, that being the logical consequence of the structure of the occupational pension scheme at issue, which covers two types of membership, as has been stated. So we don't need to get into the thickets of what kind of scheme was involved in the case being referred by the German court. The key question is, was it referable to service? Answer, yes. Did it satisfy the other conditions so that it qualified as pay within the meaning of the Framework Directive? Answer, yes. And those questions were in issue before the court and were answered positively. So one can see that the Framework Directive applied. Now, once the scheme is referable to service and satisfies the other conditions dealt with between paragraphs 48 and 55 of the judgment in that case, the pension payable under it counts as pay for the purposes of the directive. And once it counts as pay for the purposes of the directive, whatever principles apply to the directive generally apply to the scheme in Maruco. But the judgment makes clear, we say, and I'm not going to go through the passages that we say make this point good, because you've heard about it ad nauseam already. But we do say that the judgment makes clear that there is no rule restricting the right to bring a discrimination complaint to pension referable to service prior to 2003. Indeed, there isn't even a rule restricting that right to pension referable to service prior to 1990, as the court made clear. What about Römer? Well, a different tack is taken by Mr. Koppel in an attempt to distinguish Römer on its facts. The Secretary of State seeks to distinguish Römer by claiming that it concerned how much tax Mr. Römer should have to pay on his pension. Well, again, the question whether this pension fell within the meaning of pay in the Framework Directive was also in issue in Römer. It was questions 1 and 2 that the court asked. Again, if one takes up Römer, Bundle 2, Tab 12, and just picks up the first paragraph of the Advocate General's judgment, I apologise for repeating part of the Advocate General's opinion, which I referred to earlier. The reference for a preliminary ruling, this is MS 384, concerns the interpretation of the general principles and provisions of union law, both primary and secondary, relating to discrimination on grounds of sexual orientation in employment and occupation. That's what the case was about. That's why it went to the Grand Chamber, because it raised general principles relating to employment and occupation. Now, of course, it's true that there was discussion of the notional tax that would be payable, but the court's answer to the question, is this pay, makes clear that what the court was dealing with in that case was an occupational pension, payment of an occupational pension. If it were not so, the case would not fall within the Framework Directive, and the whole analysis would be vitiated. So questions 1 and 2 actually deal with that question and they determine it. It was not a case about taxation. And it follows from that that if the rule that my learned friends say applies really does apply, then Roma was a case about pension, referable to service, entirely completed before the coming into force, indeed even the adoption of the Framework Directive. It all finished in 1990. This was a man who should have got nothing if the rule that my learned friends argue for were really the correct rule. And yet we know that the answer given in paragraphs 60 and 61 of the question, see paragraphs 60 and 61, was whether there could be a temporal limitation such that the principle of equal treatment would only apply in respect of the pension entitlement earned by the pensioner by virtue of contributions after 1990, to which the answer was no. And yet it is said against us, there's another rule, nobody refers to it, but it was there all the time, that actually there was a limitation such that you can't make a claim in respect of any pension referable to service before 2003. And we say that simply cannot be right. Now, Paris. I can deal very quickly with Paris, because it was said against me that the analysis of the court in Paris shows that the Advocate General was wrong. Well, of course, it does show that the Advocate General was wrong on the point that the court was dealing with. But the point that the court was dealing with was whether Mr. Paris's claim was barred by reason of the fact, as it was put in argument by, I struggle to remember, whether it was my Lord Hughes or my Lord Reid. One of them, anyway, put in argument that the problem that Mr. Paris faced was that the boat had sailed. It had indeed sailed. Now, the striking difference between Mr. Paris's scheme and our scheme is that Mr. Walker can still get onto the boat. He doesn't want to, but he could still get onto the boat because the terms of his scheme do not require him to have been married at any particular point in time. He doesn't have to be married by the time he's 60, doesn't have to be married by the time he's retired. He can be married at any point in the future as long as it's before his death, and then his spouse will be entitled under the scheme. And just to be clear that that's the point on which the court actually determined it, if one looks at the judgment of the court, it's all very well to look at the opinion of the Advocate General. When one actually looks at the judgment of the court, the key point is in paragraph 56, Authorities Bundle 1, tab 8, MS 302. It must be noted, however, and that's immediately after setting out Mr. Paris's argument, it must be noted, however, that the fact that Mr. Paris is unable to satisfy that condition is a consequence first of the state of the law existing in Ireland at the time of his 60th birthday, in particular the absence at that time of a law recognising any form of civil partnership of a same-sex couple, and secondly of the absence in the rules governing the survivor's benefit at issue in the main proceedings of transitional provisions for homosexual members born before 1951. That's why the boat had sailed, and that's why the claim failed. So when one asks oneself the question, does the court's analysis cast any doubt at all? Obviously it doesn't support, but one's asking the question, does it cast any doubt at all on what the Advocate General said in answer to the specific submissions made by the United Kingdom to the court on this point? The answer is that the court tells you nothing about that part of the Advocate General's opinion. And so when one looks at what the Advocate General said about the United Kingdom's arguments, and in particular at paragraphs 41 and 42 of her opinion on MS 316, there is nothing in the court's judgment that casts the slightest shadow of doubt on the correctness of that. I think the way that it was put by Lord Hughes was that the critical point of distinction was that the time for fulfilment of the condition was before the relevant point in Paris, the change in law, whereas here the time for the fulfilment of the relevant condition is after the deadline for transposing the framework directive, therefore after the point where discrimination became unlawful. And when one's asking the question, and that is an absolutely critical point, because when Mr. Kavanagh opened his case and he invited the court to look at the question of what's the point at which one's entitlement becomes permanently fixed, well, that's actually it's quite a good way of putting it. You can ask yourself the question, has the boat sailed? Well, if the boat hasn't sailed yet, then your entitlement hasn't become permanently fixed. Mr. Walker can still fix his situation by marrying a woman. And the discrimination here consists in the scheme's refusal to confirm that they will pay the sum, notwithstanding that he does not wish to do that.
He's tried to board the ship, producing as his ticket a marriage certificate to somebody of the same sex.
Yeah.
And the captain, well, the purser, says that won't do. Only marriage certificates showing marriage to somebody of the opposite sex are valid tickets on this boat.
Yep.
And you say, well, that's a breach of a directive.
Yeah.
Simple as that.
Because the point at which he presents the ticket, the discrimination is unlawful.
You've only got a few minutes left, Mr. Chairman.
I have.
I want to say anything about Kukudavici.
Can I just say this about Kuchuk-Davici?
Or is that how you pronounce it?
Well, I think probably my lady's guess is as good as mine on that. What we say is this. Mr. Randall's submissions on Kuchuk-Davici simply miss the point. Kuchuk-Davici is not there as an additional point that enables us to show that the type of retrospectivity which is being claimed against us is not a problem. Kuchuk-Davici is only there if we've succeeded on the first limb of our argument, and we have convinced you by looking at Maruco and Roma and Paris that this is not actually a case that offends the EU principles against retrospectivity at all. If we have convinced you of that, then Kuchuk-Davici comes in solely to plug the point that was put in argument by Lord Reid, which is, well, what about the fact that this is a private sector pension scheme? Kuchuk-Davici answers that question. It tells you it doesn't matter that this is a private sector pension scheme, because what you're relying on is not only a principle that's contained in the directive, it's also a principle that is a general principle of EU law, and therefore any offending national provision, such as paragraph 18, must be disapplied. So that's our answer to Kuchik Davichi. Insofar as it is said against us, well, don't bother making any declaration because we don't know what's going to happen after Brexit. We say the fact that we don't know what's going to happen after Brexit makes it doubly important that you do make a declaration so that at least we know what our existing rights are. And so if, as we suppose, as we are told by the government, the plan is to bring into UK law all existing rights under EU law until such time as Parliament chooses to change them, we at least know whether this is one of the existing rights under EU law that can be repatriated, if that's the right word, by the Great Repeal Bill. So we do invite you to make a declaration. We also invite you to make a declaration in relation to the ECHR claim. That will be a declaration necessarily of incompatibility under Section 4 of the Human Rights Act. It has a separate life from the EU law claim, and for the reasons we've explained, we need it irrespective of the outcome of the EU law claim. And we do say that the complete lack of an answer to my lady's question to Mr. Koppel, which is, do you actually have any evidence of serious effects on pension funds in general, or this one in particular, to which the answer is no, is a very telling omission when one is looking at the question of justification. There simply is nothing to justify the need for this, we would say, particularly egregious form of discrimination. My Lady, my Lords, unless I can assist further, those are my submissions.
I think not. Thank you very much. And thank you to everybody for their arguments in this complicated and fascinating series of cases. It'll take us a while to work out what we think the answers may be. But we'll let you know when we have decided, in due course. Now the court's adjourned.